face an excise tax if they transact with their major donors, officers, family of donors, or other related parties. 501c4 organizations. As noted, any organization described under Section 501c is entitled to exemption from federal income tax. When we typically think of charities organized under Section 501c3, other organizations are also described under Section 501c. For example, Section 501c6 describes business leagues and chambers of commerce. Section 501c7 describes recreational social clubs. And Section 501c13 describes cemeteries. But most influential nonprofits other than 501c3 organizations are the organizations under 501c4. In relevant part, 501c4 describes civic leagues or organizations not organized for profit, but operated exclusively for the promotion of social welfare or labor unions, and the net earnings of which are devoted exclusively to charitable, educational, or recreational purposes, and no part of the net earnings of such entity inures to the benefit of any private shareholder or individual. Note that both sections, 501c4 and 501c3, prohibit private inurement and require that the earnings be used exclusively for charitable purposes. But also note that 501c4 does not prohibit political activity. A 501c4 entity is permitted to involve itself in political activity. And for this reason, 501c3 organizations often have a sister organization organized as a 501c4 through which they do their lobbying. For example, the ACLU operates a 501c3 to carry out its mission and a 501c4 to engage in lobbying. You might wonder why anyone organizes as a 501c3 if a 501c4 is also exempt from federal income tax and has more freedom to lobby. The key difference is deductibility. When a person donates to a 501c3 organization, the donor can deduct the donation from the donor's income when paying taxes. In contrast, donations to 501c4 organizations are not tax deductible for the donor. So a 501c4 trades donor deductibility for the increased ability to lobby. Potential state legislation of charities. There are some constitutional limits on a state's ability to regulate charities. In response to a conservative legal referendum, California passed a law requiring charities to disclose their donors to the state attorney general. The purported purpose was to prevent fraud and reduce administrative burdens on the government. The information would be disclosed only to the Attorney General's office, not the general public. The Supreme Court found mandating this donor disclosure infringed the First Amendment's guarantee of free association. Citing to earlier attempts to unmask donors to the NAACP in the 1950s, the court ruled that compelled disclosure of affiliation with groups engaged in advocacy may constitute as effective a restraint on freedom of association as other forms of governmental action. I'm grateful for the opportunity to share this information with you, and I would be happy to meet with any senators seeking additional clarity. Warm regards, Paul Weitz. My second item is a chart from an article in Forbes magazine. Alana Rudder and Kelly Main wrote an article titled 501c3 versus 501c4, Differences, Pros, and Cons. The article contains good information regarding differences between 501c3s and 501c4s. Today, I'd like to focus on the chart that's been handed out that denotes the similarities and differences between two types of nonprofits. If you look at the chart, it indicates differences between purposes, exemptions, deadlines, application fees and forms, political lobbying, educating about policy, funding, endorsing and campaigning for or against political campaigns and candidates, funding nonpartisan voter registration and get out to vote drives, political education, and debate sponsoring between candidates. Many of these differences were outlined in Professor Weitzel's letter that I just read. The third item is from being a player from the Alliance for Justice that was also handed out. The relevant part that is bracketed on pages 2 and 3 discusses communications regarding referenda and initiatives, and specifically indicates that the general public is considered the relevant legislative body on such referenda and initiatives. And such contact with the general public would be considered direct lobbying. Such contact would then be part of the discussion referenced by Professor Weitzel, either under a consideration of substantial or when doing a monetary calculation under the 501H regulations. I'd like to thank you for your time, members of the Revenue Committee, and I am happy to answer any questions.
Thank you very much. Are there any questions from the committee? Would you just, on the last thing that you pointed out, it's the one that says
Yeah,
advocacy resources?
would you like me to read what's on?
Well, just, again, it's at the bottom of page 16 here, starts there.
Yeah, so the referendum, what I'm referring to is on page 2 of that handout, B referenda and initiatives, and I can just read the paragraph real quick if you'd like me to.
Okay, yeah.
Where communication refers to a matter that is the subject of a referendum, ballot initiative, or similar procedure, general public in the location where the election will occur is considered to be the relevant legislative body. As a result, attempts to influence public opinion on referenda and ballot initiatives are considered direct lobbying rather than grassroots. You should recall from our discussion in part 2 that a referendum or ballot initiative becomes a specific legislative proposal from the time the first petitions are circulated to obtain signatures to put the measure on the ballot. And that was the part I wanted to highlight.
Do we have any other questions from the committee? Seeing none.
Thank you. You guys were very kind.
Mr. Hunter. Is David Hunter here? Good afternoon.
Good afternoon.
In case anybody doesn't know, you're the executive director of the Nebraska Accountability Study Commission.
That's right.
Yes,
Thank you, Chairman Linehan. Shall I begin?
you may.
And members of the Revenue Committee, my name is David Hunter, DAVID-HUNTER. I am currently serving as the Executive Director of the Nebraska Accountability and Disclosure Commission, which I will refer to as the NADC or the Commission going forward. I'm appearing on behalf of the Commission to provide information about how the NADC currently interacts with nonprofit organizations. The financing of political campaigns in Nebraska is regulated by the Nebraska Political Accountability and Disclosure Act, which I will refer to as the NPADA going forward. The NPADA generally requires the disclosure of contributions and expenditures made to support or oppose the election of candidates or the passage of ballot questions. The focus of the NPADA is on the disclosure of these contributions and expenditures. The NPADA prohibits the use of public funds to support or oppose a candidate or ballot question. It likewise prohibits foreign nationals from contributing to a ballot question committee. However, there are no restrictions on the sources of political contributions based on the federal tax status of the contributor. Thus, nonprofit entities, whether tax exempt or not, are permitted to make contributions and expenditures in Nebraska to support or oppose candidates or ballot questions. All corporations, including nonprofit and professional corporations, LLCs, LLPs, labor organizations, and industry, trade, or professional associations formed under Nebraska law and or doing business in Nebraska are required by the NPADA to report every contribution made, independent expenditure, and personal service provided of more than $250, which is made in support of or in opposition to a state or local candidate, a ballot question, or any other political committee, including PACs and political parties. The NPADA requires the filing of a report of political contributions of a corporation, union, or other entity, NADC Form B7, within 10 days after the end of the month in which the contribution or expenditure was made. Business entities who are required to file the Form B7 are not required to report their sources of revenue, including donations received for general non-political purposes. However, if a business entity, including a nonprofit entity, wishes to solicit or receive contributions to support or oppose a Nebraska candidate or ballot question, they would be required to establish a separate segregated political fund, which is a type of political action committee, or PAC. This PAC would then be required to disclose contributors of more than $250. Additionally, all corporations, including nonprofit professional corporations, labor organizations, and industry, trade, or professional associations, which are not organized under Nebraska law and are not doing business in Nebraska, must report all contributions made, independent expenditures, and personal services provided that aggregate more than $10,000 within a calendar year in connection with one or more state or local elections in Nebraska. This type of filer is defined as a major out-of-state contributor. Major out-of-state contributors are obligated to report their receipts from contributors who have given more than $200 in a calendar year for purposes of supporting or opposing state or local elections in Nebraska. Major out-of-state contributors would file on Form B9. Lobbying in Nebraska is also regulated by the NPADA. As you may know, a principal is an entity who has a lobbyist that engages in lobbying activity on their behalf. A principal could be a nonprofit entity. A principal is required to report their receipts and expenditures for lobbying purposes on a Nebraska Principal Quarterly Report or a NADC Form C. Further disclosure is required of the name and address of anyone providing lobbying receipts of more than $100. However, money received for the general purposes of the principal would not be reported as lobbying receipts. So thank you for the opportunity to testify today, and thank you, Senator Linehan, for inviting me.
You're welcome. Are there questions from the committee? Go back to where you said $250, maybe like 3 paragraphs.
Mhm.
Could you, first of all, could you provide your testimony, your written, the testimony you're reading to the committee?
Sure.
Okay. So anyway, I think it's about 3 paragraphs back.
Okay. Would you like me to repeat it?
Yes.
Um,
So I understand.
I'll start with business entities who are required to file the Form B7
Okay.
are not required to report their sources of revenue, including donations received for general non-political purposes. However, if they want to solicit contributions to support or oppose, or receive contributions to support or oppose a Nebraska candidate or ballot question, they would be required to establish a separate segregated political fund, which is a type of a PAC. So PACs do disclose contributions received of more than $250 from each source of more than $250.
So does that apply to nonprofits too?
If a nonprofit had a PAC set up, then that PAC that they have set up would have to disclose their contributors.
But they can give money to a campaign or initiative, and they don't have to disclose their contributors.
So like the nonprofit itself, if they make a contribution to a candidate, they would report that on a Form B7 if that one is more than $250. And perhaps that was the one you were wondering about.
Yes.
Okay. So yeah, and that would apply to any business entity. If they make a contribution to a candidate of more than $250, they have to disclose that on a report of political contributions of a corporation, union, or other entity in NADC Form B7.
Okay, a business, but what about a nonprofit?
And I guess we would include nonprofit and for-profit entities in the category of business.
And if they give more than $250, they have to disclose their contributors? Or they have to set up a PAC?
If they wish to solicit funds for political purposes,
Oh,
then they would have to set up a PAC.
okay. I think I understand the distinction. Senator Margulis.
Thank you, Mr. Hunter, for being here. What recourse is there through the NADC if does the NADC go out and investigate these things? Must a complaint be filed? And then what recourse is there that may occur if a violation is found?
So we do, we have a mechanism to cross-check, whether contributions are being reported. The recipient committees, for example, a candidate committee would report receiving the contribution. The contributor, let's say it's a corporate contributor, they would report making the contribution. Then we're able to cross-check and make sure that it's being reported accurately. Now, if it's not, and we say we receive a complaint on that, then we could start an investigation. And if the commission finds a violation, it is up to $5,000 civil penalty per violation found.
Okay, thank you.
Thank you, Senator Van Gillern. Are there any other questions? See none. Thank you very much for being here.
Thank you.
Mr. Vokel, the Platt Institute.
Good afternoon, Chairwoman Linehan and members of the Revenue Committee. My name is Jim Vokal. That's Jimvokal for the record. I'm the Chief Executive Officer of the Platt Institute, and I appreciate the invitation today and testify at this LR 384 hearing. I've been the CEO of the Platt Institute for almost 12 years now, and I will give you a brief overview of our philosophy on the utilization of nonprofit revenue, as well as our interpretation of allowable activities. As a 501c3, we take a conservative and careful approach with the primary focus of our activities on education, educating policymakers, the public, and the media through the distribution of research, blogs, podcasts, and weekly emails. Because we take the H designation allowed for a 501c3, we can allocate up to 20% of our resources on lobbying activities. For the Platt Institute, we limit those activities to testifying and personal interaction with senators on various pieces of legislation. For ballot initiatives, while supporting a position or getting involved with the process, like gathering signatures or promoting that process, may be allowed on a limited basis as a 501c3, the Platt Institute elects to focus primarily on educating the facts of the policy itself. By engaging in the actual process or endorsing or opposing the initiative, in my opinion, dilutes the intention and spirit of the 501c3, and that is education. Finally, as a 501c3, endorsing a political candidate is not allowed, and you'll never see our organization cross that line. I'm now happy to answer any questions that the committee may have.
Thank you very much. Are there any questions for Mr. Vokel? So you yourselves have decided that you're not going to engage in campaigns
Correct.
or referendums?
Well, yeah, ballot campaigns. The campaigns of elected officials are clearly not allowed as a 501c3.
Right.
Donations, process, endorsing. And if it's a ballot initiative, you can weigh in on a limited basis, but you cross the line if you move over and endorse a candidate in the process.
Okay, thank you. Yes, Senator Cal.
Thank you, Chair Linehan. Mr. Vogel, you said that you guys take the H designation. Can you explain to me what you mean by that?
Yes, so as the legal counsel explains, 501c3 is eligible to take an H designation, which then gives you a quantifiable amount that you can lobby based on your revenue and the number of resources. So based on our revenue, we can allocate up to 20% of our resources towards lobbying, which we do track from a time and a money allocation standpoint to make sure that we're complying. And we are always well under, because the primary focus of our organization is education versus advocacy and lobbying.
And you have to have it. I'm looking at a sheet here of the organizations who are invited to testify, and some of them have it specified that they also have a 501H. Yours doesn't. Do you have to?
That's the same thing.
Special?
We're a 501c3 with
With
the
H.
H.
Okay.
Yeah, that's
Got it.
the same thing.
Thank you.
You're welcome.
Thank you, Senator. Cal, is there any other questions from the committee? Seeing none.
Thank you.
Very much.
Have a good
Appreciate
weekend.
you being here. Mr. Gage.
How are you doing?
We're fine. How are you?
Good. Chairwoman Linehan and members of the committee, my name is John Gage. That's JOHNGAGE, and I am here on behalf of Americans for Prosperity and Americans for Prosperity Foundation. AFP and AFPF are two distinct organizations with two distinct missions, areas of operation, and both are independent in their decision-making. Americans for Prosperity is a 501c4 grassroots organization. The organization's mission is to create change through our grassroots policy, government affairs, communications, political, and education and training capabilities. Because of these capabilities, we believe we are the best organization to change the policy landscape in America. As noted in our mission, our organization is involved in the following areas: public and issue education, academic and policy research, grassroots lobbying, direct lobbying, state political activity, and state express advocacy. AFP is legally allowed to be involved in federal political activity and federal express advocacy, but voluntarily chooses not to. Americans for Prosperity Foundation is a 501c3. The mission of the organization is to empower and educate Americans on the proven and principled solution to our country's most challenging issues. The organization operates in two areas: public and issue education, as well as academic and policy research. The organization does not engage in grassroots lobbying, direct lobbying, state and federal political activity, or state and federal express advocacy. While legally AFPF is allowed to engage in grassroots and direct lobbying, the organization voluntarily chooses not to. Because both organizations are distinct, there are limitations placed on information sharing between AFP and AFPF. For example, AFP will not share or discuss current or future lobbying targets with AFPF. We can share information regarding the general legislative landscape, just not specific lobbying targets. AFPF does not encourage people to lobby, and included in this is they do not urge people to contact legislators or on particular issues or bills. Americans for Prosperity Foundation also does not discuss current or future political activity, and Americans for Prosperity does not share or discuss any current or future political activity with AFPF. When it comes to my roles within each organization, I spend most of my time working for Americans for Prosperity. When I come and testify on a bill, that is in my capacity as the state director for Americans for Prosperity and does not represent the views of Americans for Prosperity Foundation. Additionally, when knocking doors or making calls for state candidates or policy advocacy, this is done in my role for Americans for Prosperity. Most of the interaction the members of this committee have with me would have been in my capacity as the state director for Americans for Prosperity. Americans for Prosperity Foundation has a much smaller footprint of activity in Nebraska. AFPF will sometimes host trainings or informational seminars for Nebraskans. An example is last year, AFPF hosted a series of free trainings for Nebraskans on how to impact your elected officials. The trainings went over guidelines of how to interact with public officials, but did not push specific policies or pieces of legislation. I'd like to close by mentioning that AFP and AFPF both hold legal compliance as a primary value for both their organizations. A mantra we have at AFP is stop, think, and ask. And to make sure that whatever activity we're engaged in complies with the law. It's a task and a duty we take very seriously. I hope this information was helpful, and I'm open to any questions from the committee.
Thank you very much, Mr. Gage. Are there any questions from the committee? Senator Ron Gillen.
Yep, thank you for being here, Mr. Gage. You work for both organizations.
So I work primarily for Americans for Prosperity, but we do work with Americans for Prosperity Foundation.
Okay, all right. Not a trick question. I'm just reading your testimony. You say AFP will not share or discuss current or future lobbying targets with AFPF. Yeah. I have a lot of conversations inside my head. Must be real confusing for you.
Well,
how do you draw that line? Where's the iron curtain there?
So so AFPF could do lobbying, but we choose not to. So there's no lobbying done by the foundation.
Okay, so are those decisions made at a board level that then you are given a directive on how to approach? Are there other strategists within the organization that may make those target decisions, or?
I'm trying to interpret your question here. Basically, I mean, there's just, AFP Foundation does very little in the state. They don't lobby, so there's not like coordination with talking about that at all. Even if I think legally there probably could be, but it doesn't happen because AFPF doesn't involve itself in particular issues.
But there's a board that gives you direction on how to approach different matters and where to be involved, or there's leadership.
When talking these issues through, I would talk with our legal counsel about how to best approach it.
Okay, thank you.
Thank you, Senator Van Gillern. Are there any other questions from the committee? So the foundation is a 501c3
Yes.
and AFP is a 501c4.
Yep.
So the C4 can do advocacy, lobbying,
Yes.
but the difference is if I was to donate to the C4, it's not deductible, right?
Yes.
But if I donate to the foundation, it is deductible.
Yes.
So that's a huge difference here. Are we using basically tax-free money can go to a nonprofit that's doing education or religion?
Yeah, the tax-free money that's going to the foundation is only used for educational and research purposes,
Not for lobbying.
not for lobbying.
Okay, thank you very much. Are there any other questions? Seeing none, thank you much.
Thank you.
And then next. Is our own, Ryan? I guess you're mine, actually, not the committee's.
Good afternoon, Chair Linehan and members of the Revenue Committee. My name is Ryan Yang, or Y-A-N-Y-A-N-G. I am Senator Linehan's legislative aide. I'm here to share some information with the committee on LR 384. As you know, LR 384 is a study on nonprofits and their ability to use non-taxable revenue for advocacy purposes. At the core of this issue is whether 501c3 nonprofits are using their non-taxable revenues for lobbying, campaigns, legislative support, or grassroots lobbying. I will be discussing the connection between nonprofit entities in Nebraska and their use of funds. And we also want to understand how 501c3 funds can be used. Nonprofits across Nebraska provide valuable services. Consequently, our tax code is generous to nonprofit organizations as they perform much needed charitable work in our communities, often providing resources.
Excuse me, Ryan, were you going to hand out your testimony?
I thought I had copies. Can you get copies? We can get copies. I can get copies.
Sorry. Go ahead.
Let's see, often providing resources and services to constituents that are not otherwise available. However, there are limitations to how 501c3s can use their resources. Over the past several years, multiple nonprofit organizations have played significant roles in the lobby and during campaign initiatives. Our goal today is to make certain that the public is aware of how significant this influence may be. So I will discuss two examples, Open Sky and Stand for Schools, and their connections to the Sherwood and Whites Foundations. So the Sherwood Foundation and Whites Foundations are closely connected to advocacy in Nebraska, and I will also discuss how the funds of many prominent Nebraska organizations are also connected. So in 2023, Open Sky received $279,943 from the Sherwood Foundation and $260,000 from the Whites Foundation, totaling $539,943 from these foundations alone. Furthermore, Open Sky has a long history of receiving funds from the Sherwood and Whites Foundations as far back as 2016 and 2019, respectively. In 2023, Stand for Schools received $276,675 from the Sherwood Foundation. As many of you know, when you ran for office, you had to file donation and expense reports to the NADC. For ballot measures or petition drives, there's also similar requirements under Nebraska law. So this should be coming out right now. So we're handing out right now the Form B1 from the NADC.
We already have it,
Here we go.
I
Okay.
think, right? Yep, this one.
So on this form, we can see how much money was contributed to the campaign against LD 1402, which was the 2024 school choice bill passed by the legislature and signed into law by Governor Pillen. As you can see, if you turn to page 10 on the form B1, Open Sky contributed $92,000 to the Support Our Schools campaign. The year before that, in 2023, Open Sky contributed $131,000 to Support Our Schools for the first anti-school choice petition against LD 753. While the Sherwood Foundation gives millions of dollars in grants to many good causes and organizations throughout the state, many of these organizations are very closely connected to advocacy and lobbying on the state and local level. Examples of 501c3 organizations involved in public policy are Stand for Schools, Nebraska Civic Engagement Table, Civic Nebraska, League of Women Voters, Center for Rural Affairs, Women's Fund of Omaha, and the Nebraska Children and Families Foundation. Interestingly, Vote for Schools, Stand for Schools, Second House Collaborative, and the Nebraska Civic Engagement Table all share the same address. Also, Open Sky, Stand for Schools, and Nebraska Civic Engagement Table have registered lobbyists with the legislature. This information can all be found on the IRS Form 990, which is used by the IRS to track grants made by 501c3s along with other financial information, such as stock holdings and grants made to the nonprofit. The number of times that organizations like Open Sky have appeared to oppose or support legislation is another example of 501c3 involvement in advocacy for or against legislation. Since 2016, Open Sky has appeared a total of 185 times at the Revenue Committee hearings. A total of 108 of those times were in opposition to legislation. For some years, such as 2021, 2022, 2023, Open Sky testified at more than half of the hearings at the Revenue Committee for those years. This does not include the number of times that they may have submitted online comments, nor does it include the numerous bill hearings that they attended for bills and other committees. It is apparent that groups like Open Sky and Stand for Schools are deeply entrenched in advocating for legislative outcomes. An action organization, which cannot be a 501c3, is determined by two characteristics under federal law and rules. The first being that the organization's primary objective can only be obtained by legislation or defeat of legislation, and two, it advocates for the attainment of that primary objective as opposed to merely conducting nonpartisan analysis, study, or research. Continuing with the example of Open Sky and Stand for Schools, Open Sky's most recent IRS Form 990 states that their mission is to, quote, improve opportunities for every Nebraskan by providing impartial and precise research, analysis, education, and leadership, end quote. Open Sky's Articles of Incorporation state in Article 3 what their functional limitations are. This is in Section 3.2, which quote, the corporation, Open Sky, may engage in any lawful activity permitted by the Nebraska Nonprofit Corporation Act, including the making or distributions to organizations that qualify as exempt organizations under 501c3 of the Internal Revenue Code. Provided, however, that the corporation shall neither conduct nor carry on any activity not permitted to be carried on by a corporation exempt from federal income tax under Section 501c3, end quote. Furthermore, Stand for Schools, their IRS Form 990 also states that their mission is to, quote, support Nebraska's public schools working to advance policies that make them stronger while opposing policies that would weaken them, end quote. Stand for Schools' Articles of Incorporation also say in Section 4 in the second paragraph, no substantive part of the activities of the corporation, Stand for Schools, shall be to carry on propaganda or otherwise attempting to influence legislation, and the corporation shall not participate in or intervene in, including the publishing and distribution of statements, any political campaign on behalf of any candidate for public office, end quote. Throughout their involvement, Open Sky has frequently advocated for more progressive tax systems and has often spoken in opposition to bill proposals that they claim are regressive. There should be an example in front of you of these items.
The only example we got was this, so I don't know what we're.
Yes, yes. So you should be receiving the Articles of Incorporation, but there's another example their publications.
We can get an example of
Okay.
Go ahead.
Open Sky often publishes online articles and issue briefs about legislation, many of which lean towards striking down or promoting bills. Stand for Schools also publishes blogs and articles and often takes aim at any bill proposals that hope to create school choice or change school funding. On their own, organizations like Open Sky and Support Our Schools would appear to be advocating for their respective interests permissible in law. On one side, Open Sky advocates for fiscal policy. On the other, you have Support Our Schools that promotes policy that creates more funding for public schools with aims to not create school choice. However, when viewed from the larger perspective of where the money flows, there have to be serious questions on whether or not these nonprofits are acting on their own accord or acting on behalf of their significant donors. From our perspective and through our research, it appears that there are deep ties between certain 501c3 organizations and legislative initiatives. The heavy involvement in the school choice ballot petitions, their frequent testimony in support or against legislation, and calls to action regarding legislation appear to violate the 501c3 rules and statutes. It is fair to question whether there is coordination between these groups. It is also fair to question if these groups should receive the same tax benefits as 501c3s or if they should be classified as 501c4s. Thank you. I'm happy to answer any questions.
Is that your testimony?
Yes. Yep.
So go back to, excuse me, are there any questions for Mr. Young? Yes. Senator Howe.
I have a few. Thank you, Chair Linehan. So I'm looking through the chart and maybe you can help walk me through some of this.
Yes.
It shows that the NSEA, the Nebraska State Education Association, has collected $712,881.32 in contributions for the election year to date. So
Yes.
since January, they've got almost $750,000.
Correct. Yes.
Can you show me where it says what they spent that on? Or do you know, is it in here and I just missed it?
The Form B1, as far as I'm aware, it only tracks the donations to a political campaign. It doesn't show how much money was actually spent on certain things. Oh,
It's
sorry.
in the back.
It's in
It's in the
sorry.
back. Okay.
But yeah, because some funds are devoted to specific items, but generally there's the tracking of how much money was donated to the campaign.
Okay. And then as I'm looking through some of these descriptions, signature gatherings, so Vote for Schools had $200,000 signature gathering paid to Blood Communications. Is that Senator Blood?
I am actually not sure.
Okay.
I've looked up some of the organizations and I've looked at so many of them that they've all blurred together, so.
Okay, thank you.
Other questions from the committee? Isn't one of the reasons that that staff thought that these groups were connected, and these aren't numbered, guys, so it's Schedule B. So let me see how many pages are. 1, 2, 3, 4, 5, 6, 7, 8, 9 pages back, Schedule B. If you go to the next page where you have Stand for Schools at 211 North 14th Street, Vote for Schools at 211 North 14th Street, Second House Collaborative at 211 North 14th Street. It appears that they're connected, right?
Yes.
Because they're all at the same address. Was there somebody else at that address?
Yes, there was, of those organizations, it was Vote for Schools, Stand for Schools, Second House Collaborative, and Nebraska Civic Engagement Table. They all share that same address.
So are there 990s for 2023 available for Stand for Schools or for Open Sky for 2023?
No,
They are for other organizations, though, right?
yes, correct.
So when are they supposed to file those?
Those should be filed, I think, in the beginning of August, and they should be visible for the public mid-August.
Okay, but we still haven't been really looking.
No.
You want to talk about this? Hang
Sure.
on.
That's a good question. While we're-
Oh, I'm sure.
Yeah, well, we're still on that same page. Are you aware of any strategy that would be behind, for example, Second House making 4 donations within 2 or 3 weeks of the exact same amount, and Open Sky making 2 contributions within a little over 2 weeks of the exact same amount?
I'm actually not sure. I saw that myself and was a bit perplexed as why several different donations were made. The reason I could think is because when you donate on the Form B1, when you donate, there are different time periods when the campaign has to record.
Right.
And so I would think that maybe it's a way of showing that, you're only donating incrementally versus like one big lump sum. Or the funds could be donated at the time of need, which is, let's just say, for example, they needed $100,000.
Yeah, some of these were actually on the same day.
Yeah, and so that certainly did perplex me a bit, and I
Okay, I was just curious. Same with Nebraska State Education Association, 2 contributions of the exact same amount.
Right.
And then this might be way out of your area of expertise, but I'll ask anyway. Are you aware, other than an IRS or a Nebraska State Revenue violation, are there any penalties for violating the C3, C4?
I know
statutes?
there are, but I would defer that to Professor Weitzel. He's explained it to us before, but I don't want to misquote him. So.
Okay, thank you.
Now, you want to go through this?
Yes. So this packet, this colored one here, just on the first page. So this is Stanford Schools, right on the first page on the website. So on this front page, we have 2 key things to note, which is that we have the donate button, which is as a C3, that's fine, but they're donating specifically for the intentions of the anti-school choice petition. So that, now, of course, not being a lawyer, but to my Joe Schmo eyes, that seems to be a violation of the C3 rules. And then also there's take action at the top. That's another tab that you can click, and it directs you to contacting legislators, to getting involved in the petition drive, which as a C3, as we said before, is permissible in certain amounts, but when it's basically the premise of your entire website, that is questionable at least. So the next few pages, these are articles by Open Sky that have been posted over the years concerning school choice and their information, usually detailing about why school choice initiatives and legislation in the Nebraska Legislature are not beneficial to Nebraskans. And so this is pretty clear, as you can if you can take a look at it. They're obviously against school choice, right? So the clear writing on the wall from Open Sky is that school choice initiatives are something that they are against, not just neutral to, as you would expect from nonpartisan fiscal analysis, but it's something that throughout the years that they've testified to and that they've written publications on, it is something their organization is against. And then on I think, let's see, the third publication by Open Sky, the third page, I should say. At the bottom, we can see that there's a directing of Open Sky on their website to the Support Our Schools Coalition website. So that same website that we saw in front here. So they have a link that takes you back to that website to say if you that Open Sky is joining in partnership with Support Our Schools Nebraska to go against the LB 1402, and they also did the same for LB 753.
So they are coordinated.
I would believe so, yes.
It appears that they do some coordination.
It certainly appears that way, yes.
Yes.
Thank you, Senator Renahan. I just want to go back just real quick. The address that you brought up here, did you look up 211 North 14th Street?
I don't recall where it is.
So it's a building called the Foundry, which is an office share space where you can rent an office to essentially work.
Mhm.
Just because two different places rent an office in the same building doesn't mean they're necessarily working together, correct?
That is correct.
Okay, because I rent an office in a place called the Turbine Flats, and I have no idea who's next to me on a regular basis. I just want to make sure that's clear. Is the contention, zooming out, I just want to make sure I understand what we're talking about here. Is the contention here that there's coordination amongst 501c3s?
No, not necessarily. The contention is 501c3s using their non-taxable revenues to coordinate political efforts or advocacy efforts.
Okay. And is the problem, I guess, that you're trying to identify that there are similar donors to them?
Not necessarily donors. It's really whether or not the non-taxable revenue should be used at all. So for example, if it's 501c3s can coordinate amongst each other for their charitable interests, right? But we know under law, they're not allowed to do so, and they're not allowed to use their revenues within certain margins in certain tests, as Professor Weitzel stated in his testimony. They're not allowed to use those monies for political campaigns, for advocacy. And so if there appears to us to be some sort of coordination between 501c3s, common 501c3s, that share common goals, that share a common address, and some of them even sharing common officers and members, that they're directing their monies towards certain legislative outcomes.
Okay. If they did use their money, though, within that margin, that 20% we talked about for the H status or whatever that is, then it'd be fine.
I believe so, but that would be up to a court to interpret.
So the question is whether or not they're utilizing that money within the reasonable margin.
Yes,
Okay. But if they are doing that, then everything you just described is acceptable.
under the law, yes.
Okay. Thank you.
Thank you, Senator Duncan. Other questions, Senator Powell?
Thank you, Chair Linehan. Mr. Yang, and I don't know what page it is, but it's the last page. It's Nebraska Education Collaboration. Do you know, so it says a collaboration, Nebraska Council of School Administrators, Nebraska Association of School Boards, Nebraska State Education Association, Schools Taking Action for Children's Education, Greater Nebraska Schools Association, Nebraska Rural Community Schools Association, Educational Service Units Coordinating Council, and Stand for Schools. Are those all 501c3s?
Not all of them, no.
So they're all kind of mixed. So that you've got the 501c3s, 501c4s. Does the fact that they're publicly stating themselves as being part of a collaboration mean anything significant if they're not all the same type?
It certainly does, because on its own, at face value, you wouldn't think twice about it, right? But then when you look towards, for example, this letter in particular, it's not the first time that they've sent letters in this form. This particular letter was addressed in regards to the tax package plan that was proposed by Governor Pillen this year in the special session. It was this same letter format was used a number of years ago for another, I believe it was another school choice bill. Having them associated together in that same manner definitely, to us, appears to be some sort of indication that these groups, not only ideologically or in terms of mission and goals, agree, but that they're actually, as the letter shows, that they're actually coordinating with each other to promote the same statement.
Okay, thank you.
Thank you, Senator Powell. Senator Weingiller.
Just to follow up to Senator Duncan's question or comment about the H status, going back to Professor Weitzel's letter, the 501H requires that they opt in, and then it sets limited, that 20% limitation is for an organization that has expenditures of $500,000 or less. Do you have any idea whether these organizations, what their total expenditures are?
Yes, it's on the IRS Form 990. For example, Open Sky, their total lobbying, what they wrote in as their lobbying funds was about $120-something thousand. That was for 2022, because obviously we don't have 2023. However, sorry, go ahead.
But what were their total expenditures?
Open Skies was total about just over $1 million and change.
Okay, so 120 and $1 million would be 12%, which would be
Right.
within the 20%.
Right.
Okay.
So
If they did the H opt-in
if they did the
designation.
H,
They did.
which they did, but it also, on the H designation, at least on the 990, so there's a matrix on the 990 that shows if your revenues are at within certain brackets, you can use a certain percentage of that revenue or of those expenditures for lobbying. Now, as Professor Weitzel has stated, that's what the IRS Form 990 says, but the general interpretation is always deferred towards, or not always, but is generally put towards the holistic, not just how much are you spending, even if you do the H designation election, but also what are your activities as a whole, because you can spend, well below the 20% as outlined under, the rule that he cited or the 990 form. But if all of your activities outside of that are based on advocacy, even if you're spending no money, well, at least from what Professor Weitzel said, a court is likely to look at that and look at it holistically and say, well, that seems a bit funny to us. So
Do you know offhand if these organizations are audited, if they do a self-audit, or if there's a required audit that would confirm those figures? Or is it self-reporting?
No, so no, and 990s are part of like their way, the nonprofit's way of like self-reporting how much they generate or how much they give out in funds. So
Okay, thank you.
Any other questions? I think some of the confusion here, and maybe it's a lot of stuff, and not having your testimony in front of us was a lot. Okay. It's the definition of what lobbying is.
yes.
So it's very specific. If you talk about a bill, a legislative initiative, it's lobbying.
Yes, correct.
So anybody that comes in here, as I think Mr. Vogel made clear, they come in here and they're testifying for or against a bill, that is lobbying.
Correct, yes.
If you pay a lobbyist who's on retainer for your association, that is lobbying.
Yes.
And then what we discovered today, thanks to the information that I think the Sherwood Foundation sent to us, is if you're involved in any initiative process, a ballot, as soon as the first petition is introduced, or as soon as someone shows someone a petition, then everything that's spent on that is lobbying.
That's correct, yes.
So if you take their blogs and all of their, everything Open Sky or Stand for Schools would have, where they're asking people to contact a senator or take some kind of any action that pertains to the legislative body, or in the case of petition, anybody in the state of Nebraska that's eligible to sign a petition, that would be lobbying.
Yes, correct.
Not just what appears they've reported in the past, what they pay their lobbyists.
That's right, yes.
It's a definition of how loose we've gotten with what is lobbying.
Yes, yes.
Any other questions? Okay, then you and Charles and Josh will write a report, right?
Yes, we will, yes.
So if any of you have additions or want other things looked at, we would appreciate your input. Okay?
All right.
Hearing's over. Thank you very much.
Are you closing it all, or are we done?
We're good. It's over.